but two wrongs do not make a right. Thank you, everybody.
Thanks so much, Senator Booker. Yeah, it really is immense trust and confidence that he's placed in with this. I mean, for all he knows, I could spend the whole afternoon talking about the Dormant Commerce Clause now, but we won't put everybody through that. There are a few follow-ups I want to answer. Mr. Bullard, you mentioned the benefits of the OFF Act, and I appreciate your support for that in your comments. How, in your view, has USDA oversight failed to oversee the checkoff programs adequately, resulting in some of these problems in the programs?
So historically, it's been a hands-off approach by the U.S. Department of Agriculture. A private consultant found in 2010 that there were about $200,000 and some were misappropriated out of the checkoff funds. Soon thereafter, the OIG did an investigation and completely ignored that malfeasance. And upon our complaints, they redid their report, and suddenly they made mention of it. But so the U.S. Department of Agriculture was asked for many years to separate the organization that's the major recipient of the beef checkoff program, to separate what the subgroups they had within their organization that they claimed to have a firewall between. But, and that's the Federation of State Beef Councils that's housed within the National Cattlemen's Beef Association. But no action has ever been taken. So even though the USDA was well aware of the problems, no action was taken. We ultimately filed a lawsuit alleging that the lack of oversight on the part of USDA constituted a unlawful subsidy, a violation of the Constitution, where producers were compelled to fund the private speech of private entities. And through the course of that litigation, USDA did make some reforms, but they are inadequate to protect the producers against the ongoing assessment against them, the tax, that still funds policy initiatives that are contrary to their interests. Funds by way of lobbying, providing organizations the ability to lobby.
I remember Robin Williams joking about the unarmed English Bobby, who upon seeing the commission of a crime would shout, "Stop," or I'll yell, "Stop again," because he's unarmed. Is that sort of what you're describing here, is that maybe they're aware of problems, they're not enforcing them, and they just go unenforced?
That's very possible. There appeared to have been no will whatsoever to enforce the act.
Ms. Mecki, let's go to you for a moment. You noted that nearly 1 in 4 public comments identified healthcare competition concerns. And I don't doubt that at all. I mean, just knowing how people feel about those issues generally, and knowing what we've seen has happened with consolidation in that industry and what has happened as a result, it ends up being problems. What specific actions do you think might be most helpful in ameliorating this problem and addressing the issue of excessive consolidation within that industry?
So there are things that I can't talk about publicly based on work that I did when I was at DOJ, but I will say that I hope and trust that the Justice Department's Antitrust Division is focused on enforcement against some of the private regulation side of the ledger. There are also myriad regulations that Congress and the agencies could work together to address, right? There are kind of arbitrary rules, including things like the ability of the federal government to negotiate drug prices with drug companies for Medicare and Medicaid that, to me, seem extraordinary. And I know there have been some gains with recent legislation, but this is a market that government itself has created and funded, and the ability to, the fact of not being able to negotiate prices fully is really extraordinary to me. Even in the face of prior authorizations and distant, faceless, sometimes nameless personnel who decide whether a doctor's decisions to, prescribe certain medications or recommend certain courses of care, they can veto that, right? And even when Americans are facing those kinds of circumstances with their health insurers, they're not allowed to switch their health insurance except for once a year, right, for most
Right.
people. And so that, again, that is an example, that is regulation too. And there's an arbitrariness to it that deprives consumers of choice and really tilts markets in favor of health insurance companies. I think there are myriad examples like that, but there is a structural problem with our healthcare markets. I had the pleasure of doing both civil and criminal enforcement when I was at DOJ, and there are sort of hallmarks of different kinds of frauds and schemes that you sort of see built into the structure of our healthcare system, right? There's opacity, there's tremendous distance between who's paying and who's receiving services, and all of those characteristics make me worry hugely that we don't actually have a real conception of the cost of delivery of care such that we can get in and make things better. And if you'll indulge me, I have to say, I was listening to a guy named Michael Zembalist recently, and he's, I think, like the top investment officer at JP Morgan. So this is someone who sits on investment committees and has to make decisions about the allocation of securities and assets for pensions and foundations and funds of all types. And he was asked, what is the market that he has the most trouble cracking? And he said healthcare, right? And this is someone who's figured out, keys to unlocking the energy crisis as we see an explosion in AI services in the product ecosystem, who's really taken a close look at big tech and other markets that are quite difficult sometimes to navigate. But healthcare is the one that is the most opaque and mysterious, even for someone whose full-time job it is to understand markets and make money for a very large bank.
Can I just have a quick comment on that? Because we inherited some of the healthcare cases that she is referring to. Right. And so I just want to say that at the Department of Justice, Attorney General AAG Slater has healthcare antitrust enforcement as her top priority. It is an absolutely critical aspect of the work, and we talk about it every single week. And so we really are at an inflection point for a variety of reasons. We have an executive order on deregulation in which the other agencies are mandated to cooperate with us on anti-competitive regulations, and we're working actively with other agencies in the healthcare space. We also have separate EEOs on drug prices and ordering that we address drug pricing crisis and that mandate. And then we have years of investigative work that has been done at the DOJ prior to our arrival, in which we can then pick up that mantle and try to look at what are the appropriate antitrust arguments on the litigation side. And imagine the excitement that the DOJ antitrust lawyers felt when they won the Google case and then won the next Google case. Imagine the same kind of excitement that we'll be having when we successfully win a healthcare case like that and successfully get regulatory reform to address some of the healthcare crisis. That's what we're looking at.
Thank you. Both of your answers are very helpful. And Ms. Mecchi, I loved your description of, hadn't quite thought through to that extent. You're describing essentially switching costs. And switching costs made more complicated by virtue of the narrow time window in which Americans, particularly on an employer-sponsored plan, but really on most plans, have to make a decision more or less annually. And if it is an employer-sponsored plan, as is often the case, they'll also be somewhat limited based on which plans their employer is willing to consider. And with the Byzantine labyrinth of federal regulatory requirements that they have to comply with in order to do it, that itself probably interferes with their ability to disrupt the marketplace through more innovative plans. Is that a fair characterization of some of what you've said?
That is certainly one flavor of the problem. There's also just, going up a level, most people really struggle to shop for healthcare. It is so complex. And again, if you're a new health plan and you're operating in, as you noted, the labyrinth of different requirements, whether imposed by the federal government or a state government or the private monopolies, you are essentially having to take little nibbles as opposed to doing big, sweeping, innovative, great things that the American people, all else being equal, may well prefer to the existing plans.
Right. No, that's a great point. And some of those monopolies, or there's been consolidation in the industry. That consolidation has led to a smaller number of major players having a significant sort of dominant control over that industry, in part because the regulatory nature of things will tend inevitably to make it easier for a startup, a new competitor, to come onto the scene. Yeah, that's an entrenched problem. Mr. Metter, after sifting through the 400 comments or so, what are your insights on this and where we ought to go with it?
As I mentioned in my opening remarks, I think the key insight is that we are seeing a similar perspective across multiple different parts of the American economy. Individuals, small businesses, organizations that represent multiple businesses are all pointing out that many of our regulations do seem tilted in favor of large incumbents. They prevent entry. They're frustrating consumers getting the outcomes that they're looking for. And so I think this is a target-rich environment, both for antitrust enforcers, for regulatory agencies, and for Congress to step in and fix the problem to make sure that our regulatory system and our law enforcement efforts all work to the benefit of American consumers.
Great. Mr. Alford, I want to go back to what you were talking about a minute ago. Given the wide variety of state-level regulations, from rent control regimes to livestock inspection requirements, how does the Antitrust Division plan to coordinate with state attorneys general and legislatures in order to identify and roll back some of the more burdensome and anti-competitive restrictions?
Yeah, it's a great question. So as you look at the sort of deregulation projects that one can envision, you have a four-box matrix. You have federal laws, you have federal regulations, you have state laws, and you have state regulations. And we've been speaking to a large extent about federal regulations and working with other federal agencies, but Professor Francis had identified some of the most important issues are with respect to state laws. And so in that respect, I think there's a variety of things that could happen. He's already referenced the Dormant Commerce Clause. You've referenced the Dormant Commerce Clause. In the first Trump administration, we did use the Dormant Commerce Clause as an antitrust tool as a possibility. We also routinely engage in advocacy at the state level to try to address concerns, typically in the context of encouraging the enactment of laws that are pro-competitive rather than anti-competitive. But I do think you're right that we do need to talk with the state AGs and with the state legislatures to see if we can make the case for a modification of some of those state laws. And then the final option that I think Professor Francis mentioned is there a role for Congress to try to deal with things that would create the preemption that you need to deal with truly anti-competitive regulations. And it's not just about healthcare, as you said, it's agriculture, it's housing, it's franchise dealer laws. There's a whole variety of different examples of state laws that are problematic.
All right. Let me make sure that that covers it. I think we're good. Anything else, guys? All right. Really appreciate you being here. All five of you have contributed very meaningfully to this conversation. It's been really helpful.